Well, some of these politicians should learn to talk a little less, because the attacks on the Supreme Court are extraordinary. They're very much a confession through projection context. Like I've told people, if you want to know what's really happening in the Ukraine-Russian conflict, listen to what Ukraine says and assume they're about Russia and assume they're talking about themselves. More proof of that. Because to this question, what happens when they do this? That's what we're transitioning into right now. Just as in Ukraine, confession through projection, and then they're firing military people and security people and law enforcement people because it turns out all of them are dissenting. So what they were accusing Russia of, the massive dissent within their law enforcement, intelligence, and military, is in Ukraine. And it will always come out a little bit later. But these politicians, everything they said about Trump, they have been guilty of. And a political weaponization of the prosecutorial process, the corrupt family members at an extraordinary level in sex scandals, personal scandals, financial scandals, bribery, extortion, embezzlement kind of activities, as is detailed in every new latest Hunter Biden laptop release or phone release or leak release. And we've seen it in the Uber leaks as well as more examples of that. The Italian government partially collapsing because of some of its policies related to it. But the attacks on the rule of law, there's been no greater attack on the rule of law than what we've seen in response to the Supreme Court's latest 3 decisions. Their decisions on the Second Amendment, their decisions on abortion, their decisions on the power of the administrative state are all going to get tested right away, because the state of New York, now a bunch of the states, California, everybody's trying to figure out ways to completely ignore the Supreme Court's ruling. So they want to stack SCOTUS. They can't stack SCOTUS. They want to scrap SCOTUS. And their means of scrapping SCOTUS, some have explicitly called for abolishing the Supreme Court. You know, that shows you where the left is. The law is just a tool, just a means to an end. They don't care about principle at all. Is the effort to now get around and directly confront the Supreme Court's rulings. So the state of New York rushes in, does a quick legislation without meaningful public participation, and the way they fix the problem it was the state of New York that was overturned for its bad laws relating to gun control. Mm-hmm. So they come in and they replace their new standard is you have to have good character. Again, the Supreme Court said you can't have a limit on licensing to bear arms. So what do? They just change the definition of what the limit is rather than recognizing they couldn't limit this in the first place. And not only do they require good character, they require you to go through an inquisition type process where you have to disclose your family members, your friends, other people who vouch for you. You have to disclose everyone you live with. You have to disclose everyone you have relations with. Not only that, you have to disclose all your social media accounts. You have to disclose your whole political history. It's absurd. It shows what they've always been about. It was never even about gun control. It was about restricting people's liberties and rights and having the state have not only a monopoly on the means of violence, but a monopoly and control over you. It's a Stasi-style, Soviet-style enforcement mechanism. And then they define sensitive places, despite the Supreme Court saying, look, don't create something that's a substitute for this. Don't create a system that has excessive fines. And don't define sensitive locations as every place in your state. That's pretty much what New York does. They go in and create a worse restriction on the ability to bear arms. They create a system, a training system that's going to be 10 times more expensive than the current one. So it's basically an excessive fine provision. And then they redefine sensitive locations to basically include the whole state. It's if there's a government entity nearby, if there's a government finance entity nearby, if there's a health entity nearby, if there's education nearby, if there's children nearby, if there's a park nearby, basically it's the whole state. You can't bear arms. So it's a patently unconstitutional provision. They have brought a great suit challenging it. And it's clear the courts are going to have to start going Brown v. Board style, holding people in contempt in state governments because they will not obey the U.S. Constitution. When you have the President of the United States calling for not obeying it, the Vice President of the United States calling for not obeying the Supreme Court, the Secretary of Human Health and Services saying he's not obey the Supreme Court. And you have governors and legislators saying we're not going to obey the U.S. Supreme Court. We are in a constitutional crisis stage because the left never gave a darn about the Constitution or respect for the rule of law. What they accused Trump of is what they were always about, which is disrespect for the rule of law, and the ends justify the means. This New York law shows what they're really about. basically taking red flag principles and making a precondition for even getting a gun in the first place, and a good lawsuit challenging it that should strike down all of these ridiculous provisions.
But this is the issue, Robert. They just got struck down by the Supreme Court. And so now what do? They come in with new regulations and they say, if you don't like it, take us to court. And I think you touched on the remedy, the ultimate remedy. This is like Sisyphus pushing up a rock. It's like you push it up and it falls back down. They're going to a new regulation. So what is the ultimate sanction to make sure that they don't just come back after every court ruling, striking it down, saying, here's another variation, let's try this one? What is the sanction? Contempt?
Yeah, well, ultimately, that's where they have to go. I mean, they're holding Steve Bannon in contempt because he thought executive privilege applied to the provisions to a congressional committee he properly thought was not properly formed. Whereas these people are and they're saying it. They're saying overtly, Supreme Court's gone too far, we're going to ignore it. I mean, they're saying this openly and publicly. So at some point, I mean, right now, they make the state pay attorneys' fees for having to litigate it, have another court issue injunctions. But it's Robert, like Brown v. Board. You ultimately, the only way you really enforce that is you start holding people in contempt.
But they pay the legal fees. That's taxpayer dollars. Nobody's paying anything. I mean, other than being politically unpopular, it's not out of their pocket. But hold on. I just want to bring this one up. Lewis S., I'm not trying to put you on blast. Your 1 in 5,000 stat isn't accurate. You have to be more diligent with your poke sources. I like you guys, but Barnes gets lazy with the poke evidence. I just quoted from the chief medical officer of Ontario, who literally said 1 in 5,000 for myocarditis of young males, I think in particular. So,
and that's only, again, what's been documented in detail. That's the low end. Chances are it's going to be substantially higher.
No question. And they'll pretend they always said it was higher. So you might have missed that part where I actually played the video of Kieran Moore, chief medical officer of Ontario. So, but Robert, to punish them, contempt is the only meaningful sanction because that affects them personally. Order to pay costs, they pay it with taxpayer dollars, so they might get outed from office the next time. This is like it's like whack-a-mole, except it's whack a Democrat politician in terms of them just passing a different variation of the very same regulation that was just struck down by the Supreme Court.
What's even more egregious is what's taking place in the abortion context. So also the people have added there is a lawsuit now challenging the national firearms registry, the federal gun control laws. Congress is trying to pass some more limits this week, which is just incredible. I mean, again, it's an attempt to override the Supreme Court. But there's lawsuits challenging that. There's going to be more lawsuits. There's lawsuits challenging existing magazine restrictions, all the other restrictions that no longer are constitutional under Supreme Court analysis of that decision. You're going to see a bunch of gun control laws struck down over the next 6 months to a year, and you're going to see a bunch of politicians writing checks to Second Amendment lawyers all across the country. But the other aspect has, of course, been Roe. And the attempts to overturn Roe, recommendations to establish abortion clinics on federal parkland, recommendations to establish abortion clinics on floating ships in international waters or federally controlled waters. And the one that the Biden administration has actually done, which is through the Secretary of Health and Human Services, once again skipping the notice and comment process, once again skipping all of the democratic participatory role for the administrative state, is they are misusing an emergency law governing hospitals not kicking out poor patients to say that now every hospital in the country has to provide abortion services as an emergency treatment. Now, there's many problems with that. It led to Attorney General Paxton filing suit on behalf of the state of Texas, challenging it in Texas, the Northern District of Texas and the Lubbock Division, pointing out all the problems with this. The first one is that, of course, they don't have the authority to do it. The Emergency Act, what happened was Congress in the mid-90s, you had hospitals that would play, they would, if somebody was too poor to afford care and wasn't covered by either Medicare or Medicaid, they would kick them out to whatever hospital might cover them. And so you had poor people in emergency rooms having to go from hospital to hospital to hospital. So they passed a law that said, if you get Medicare funding, don't do that anymore. That's all the law stands for. That law is the one that now the Secretary of Health and Human Services, the former corrupt Attorney General of the state of California, is now saying, and after that, Senator, is that law means that doctors have to provide abortion, and this executive official's rule overrides and preempts state law. It's what, by the way, conservative critics always said about Medicare, Medicaid, other aspects of federal care. They said this will be used to co-opt the practice of and profession of medicine, to preempt the state's rights to regulate and control the practice of profession of medicine within their state. So he's brought suit. He said, first of all, they don't have the authority to do it because the law never gave it to them. Second, they don't have authority to do it because they didn't go through the APA. It's an arbitrary and capricious action. There was no notice and comment period. They didn't even explain effectively why they did it and how they did it in a way that's APA compliant. Third, violates the 10th Amendment to the United States Constitution, which reserves this exclusively to the people. And last but not least, two other provisions. It violates the spending clause, because what Congress can't do is use its leverage, or federal government can't say, hey, we give you some money, so now we get to control your life, unless it was part of the original monetary package in the first place. You can't post hoc attach strings to the money. When you send the money, you can attach strings to it at that time, but you can't attach it later. Supreme Court's made this clear repeatedly. So it's an excessive use of the spending clause power. And then last but not least, it's exactly what the Supreme Court said you couldn't do in the EPA case. You cannot delegate, an administrative agency cannot claim it has legislative power on major questions, and this clearly is such a major question, when it is that the law itself didn't give it to you. Two other ancillary provisions. This executive order actually violates federal law because it violates the Hyde Amendment and violates the Weldon Amendment. The Hyde Amendment said no federal funds can go to support abortion, period. And the Weldon Amendment said you can't discriminate in any way, shape, or form in federal spending based on someone denying access to abortion. So Texas should win this case across the board and kill this latest Biden proposal to try to undermine the Supreme Court's order.
And people are using it's not exceedingly rare, actually. It's a 1 in 50 case of ectopic pregnancy to say they're going to be denied abortions for ectopic pregnancies, when it's an important distinction. Termination of an ectopic pregnancy is not even considered an abortion. It's not covered by the abortion ban. It's a medical procedure, because ectopic pregnancies, as I now know, exceptions aside, like rarities aside, are necessarily fatal and therefore pose a great risk to the mother, with no risk of viability to the ectopic pregnant unborn. So it doesn't even affect that. But they use that
and
as though
Texas, by the way, like Ohio, has an exception for the life of the mother or severe harm to the mother in its abortion laws. It's just as Ohio did. We got more information on the 10-year-old case. It appears to be a politically staged case, because they could have got the procedure in Ohio. It turns out that a 27-year-old illegal immigrant, non-resident, I think it's illegal alien would be the legal terminology under our federal law. So those people don't like it, take it up with the federal law. That's the legal definition. And was the rapist. And it appears that they went to Indiana, maybe in part to cover up his complicity, because the doctor the abortionist misidentified his age as 17 rather than 27. The whole fact this ever went public at all meant it was a politically staged event, as Tim Pool has identified that everything about this smacks of being a politically staged event. Texas similarly has those exceptions already written in. They're trying to redefine emergency care to mean any abortion, period, is what they're trying to do. And it's a patent attempt to misuse and abuse federal authority to strip a state of its constitutionally preserved under the 10th Amendment rights. So they should win on every single one of the claims, least of all just a single one of them. So hopefully Texas will put an end to this latest attempt to subvert the Supreme Court by the Biden administration.
I wanted to pull up Biden talking about the extremists. The SCOTUS has been taken over by, what did he say? Out of control judges doing the bidding of extremist elements of the Republican Party. And these are the people accusing others of insurrectionist behavior, when they are basically saying, we're going to defy the judicial branch and the rulings of the judicial branch. The executive now runs the judicial, and they're the ones accusing others of insurrection. Robert, it's nuts, but it's par for the course.
No doubt. One other component. Congress is talking about passing a law federalizing abortion protection. They can't. Two reasons: the profession and practice of medicine is delegated to the states. And of healthcare in general, so it's not an area they can federalize. And that's part one under the 10th Amendment. Secondly, this has been clarified by the Religious Freedom and Restoration Act case. So originally, Congress wanted to overturn the Supreme Court's limiting of the First Amendment's application in the religious context. So they passed the Religious Freedom and Restoration Act. But what did the Supreme Court say? The Supreme Court said you can't apply that to the states. You can apply that to the federal government, but you can't apply it to the states because that's outside of your congressional authority. So that you cannot congressionally reverse the Supreme Court of the United States in that way. You can only congressionally reverse the Supreme Court when they're interpreting a statute and then can impose a statute, or when they say there's no congressional remedy yet, you can then provide one. What you can't do is overturn their interpretation of the Constitution under existing law. So all these people saying they're going to federalize abortion protection, that is not something that can be constitutionally done either.